I promised on your show last month that this month was going to be Fourth Circuit month because you and I did the June cases like mid-July last month. But actually, and this is totally Fourth Circuit month. Fourth Circuit has gone off. The Fourth Circuit is now what people used to say about the Ninth and the Second Circuit. The Fourth Circuit is Asylum Central, pushing that law forward. The Ninth Circuit is at war with itself, and the Second Circuit just isn't publishing as much immigration cases anymore. But before I get into those Fourth Circuit cases, I'm actually going to start with the Third Circuit, because the Third Circuit and the Fourth Circuit issued essentially the same decision this year on deficient notices to appear. That pesky deficient NTA issue that begins with Pereira and Ms. Chavez at the Supreme Court in the in absentia motion to reopen context, which really is the next frontier. Because I can't, I've said it so many times on my podcast, I've even said it on your show too, like, if all of the circuits go the way that these circuits are going, we're talking about tens of thousands of in absentia motions, of in absentia removal orders issued since 1997 that almost surely began with deficient NTAs that didn't have the date, time, or location, one of the three, in that NTA, and that need to be reopened. And I'm not gonna lie, like, as by my count, they need to be reopened in the First, Third, Fourth, and Ninth Circuits, and it gets a little complicated in the Fifth. The 11th Circuit doesn't really know what's going on. It's issued a published decision that is weird, but then it disagreed with that in an unpublished decision with more, which you can't do. So it's like, what is that line to walk in the 11th? But again, First, Third, Fourth, and Ninth Circuits. I mean, that's already tens of thousands of in absentia removal orders since 97. And the third and the fourth, the third is Madrid Mancia, the Attorney General of the US. The Fourth Circuit also published just the next week in July is Lazo Gavidia v. Garland. And the Third Circuit's is more interesting. They go through the history of all this, but this is all statutory interpretation, this textualist world that we live in where judges, they only care about the text, and it's the literal meaning, and dictionaries have all this power, and we don't care about legislative intent, apparently, or fairness, or a living constitution, for example. In this textualist world, though, sometimes that can be to the benefit of the non-citizen, because the motion to reopen statute says that a court may, that an in absentia removal order, that is, they didn't show up to their hearing and they get ordered removed, may, quote, may be rescinded at any time if the alien demonstrates that the alien did not receive notice in accordance with paragraph 1 and 2 of section 239A. Restated, it gets rescinded if the non-citizen doesn't receive notice in accordance with 239A. And 239A lists what needs to be in a notice to appear, and it has to have the date, time, and location of that first hearing. And indeed, even going in absentia itself must be premised on a finding that the non-citizen received notice in accordance with 239A. That's another statute. So, like, very clearly, the in absentia statutes are tethered to proper notice in accordance with 239A. That's what the First, Third, Fourth, and Ninth Circuits have now all said. By the way, the First Circuit said it by vacating the BIA's contrary decision. So matter of La Para, in my opinion, is not good law anywhere because the First Circuit vacated it. They're all saying this because that is what the statute means. Both the Third and the Fourth Circuit, they're saying this, and they don't care whether or not the non-citizen updated his or her address properly. These battlegrounds for in absentia motions to reopen, it used to be, did the non-citizen properly give ICE their address, properly update it? That's still relevant in the Fifth Circuit, which doesn't make sense to me, but it's not relevant to the Third and the Fourth, and seemingly the First and the Ninth. This is all about the in absentia statute. It has nothing to do. And as the Third Circuit says, I mean, I'm just going to keep going on and on with it. This is the quote: "No reasonable diner would expect to get seating for two by calling a restaurant to change a reservation he made." So, like, This is the quote. The third, confusion, not a boarding pass, would follow a traveler's request to change a flight from business to first class when no seat of any kind had been purchased. This is the analogy the third is saying. It doesn't matter if the non-citizen updates their address when they haven't received the required notice in the first place. The Third Circuit's saying it with some very fun language. In dissent, the Fourth Circuit judge who was dissenting in Lazo Gavidia said, and this is not the first judge to say this in dissent, I'll quote, after the majority's decision, every non-citizen who was removed in absentia after receiving an incomplete NTA can obtain rescission of her removal order, regardless of whether she provided an address at which she could be reached, and regardless of whether she actually received the notice, but chose to skip her removal hearing, end quote. This is the judge in the fourth lamenting this. But the judge isn't wrong. The judge is correct, but this is what the statute requires. I mean, this is tens of thousands of people getting a second shot. And of course, your more stereotypical situation is these people who are ordered removed. They didn't depart. It's been, 15 years. They're married to a U.S. citizen and they can adjust status. Or they can at least get an unlawful presence waiver and consular process, but for this removal order.
So a couple of things. One is, like, you said the judge is supposed to make a determination that proper notice was made in their decision. That's one of the things. So in decisions for judges to, do in essential orders, is that part where they write, like, check the box that notice was given? Is that part of customary that judges will go into?
At every in absentia hearing, there's always going to be this preliminary determination where essentially DHS submits the NTA and the I-213. The judge says notice was proper, removability is established. And in my opinion, an IJ can't do that in the first, third, fourth, or ninth circuits. The ninth was pretty explicit in Singh. And so you shouldn't have this issue going forward, because judges in those four circuits, at least, they're probably not going to go in absentia anymore if the NTA is deficient. But of course, this is all very new. Tens of thousands have already happened. And so that's the future. They can't go in absentia in the first place, but redressing what's happened in the past, they got to reopen it. And by the way, in that Third Circuit decision, why I like it so much, I actually just used it in a brief, again, Madrid-Mencia, the Third Circuit explains how this all came to pass, at least is its reading of the history. It really begins with the Carter administration's INS, with orders to show cause, making the determination that including the date and time and location of the first hearing, the order to show cause was just too burdensome. And that is actually okay, because an order to show cause wasn't tethered to INA 239A, it didn't even exist yet. Order to show cause doesn't require, like an NTA does, post 97, that this information be included. BIA has already issued a decision on that, and in my opinion, they're right, as have some other circuits. But then after NTAs came into force after 97, INS and then DHS, they never changed their position. They actually doubled down and said, we can't do this, so we're not going to do this. And to me, that's affirmative misconduct. I mean, that's not negligence. That's not a mistake. That's like, we know what we have to do. This is a Third Circuit, by the way. We know what we have to do. We're just not going to do it. And this is the chicken coming home to roost. And what other applications can, in my opinion, affirmative misconduct by DHS and INS post 97 get to individuals who have been subject to this system?
So my second question is, should lawyers, especially in that jurisdiction, do massive amounts of Facebook ads and TV ads right now to deal with these? This is like a boom for business.
I disagree. I think that they should all come to me. And I will file. No, I mean, I absolutely. You gotta, not even more so. I mean, putting that aside, like, you gotta kind of look at like all your cases, all your past cases.
Yeah.
What was the NTA like? Should you be contacting old clients? I don't think you have that obligation, but like, that's certainly an issue spot. The moment someone comes into your door, it's as important as any issue, more important, really. Today, the BIA issued an amicus invitation that, to me, Like they could use all the fancy language they want in that amicus invitation, but to me, they should have just asked, did we wrongly decide matter of Fernandez last year or this year? I don't even last year. Like, were we wrong in what we said about deficient NTAs and whether or not and how it could be remedied? Now that's separate from the in absentia issue, but I don't understand why they issued this amicus invitation that they issued today if they weren't rethinking matter of Fernandez. Fernandez essentially said DHS can cure a deficient NTA, but as I've been arguing, what does that mean? And actually, the dissent said this in matter of Fernandez. What does that mean? DHS can't file an I-261 as they've been doing because you can't use an I-261 to amend something that isn't started properly in the first place. The 261 amends a proper notice to appear. But all of these cases are making very clear that an NTA that's deficient is not a proper NTA. So you can't amend it with an I-261. And so if that means that you need to file a new NTA when proceedings are started improperly, well, there can never be two NTAs in a case. So it really requires termination. And then DHS can do whatever they want and file a new NTA. But like, I mean, that's the board today in their amicus. I don't understand how you can create a new form. And a new regulation. I don't know. That's a bit separate, but it's all the same chaos that has been unleashed on us by Pereira and Chavez, but which really is just what the statute was always saying and what smarter immigration attorneys than me have been arguing pre-Pereira. And in my defense, I wasn't really an immigration attorney for that long before Pereira. So I'm gonna get out of it. I can't speak for everybody else.
Well, all I say is, like, if I was a young, hungry attorney that does a removal defense, I'd find these older attorneys on the verge of retirement and say, listen, I'm gonna look over your caseload. Well, split in half, but let me go back and catch all these and contact
That's
them.
a good point. Give me some money. Let me look at your client files for the last 25 years and start contacting clients. I mean, the floodgates are, it's not even discretionary. And by the way, you got decisions like matter of Chen from the board, and the circuits have said it too, that say the non-LPR cancellation of removal 10-year clock doesn't stop ticking with a removal order if the NTA was deficient.
Yeah.
I mean, so what does that mean? Like, even for the people who don't have qualifying relatives and who weren't ordered removed in absentia, if you can meet the other burdens for reopening, then you have a valid motion to reopen. If, for example, non-LPR cancellation was denied way back when, because you didn't have the 10 years, based on a determination that the NTA stopped the clock, it didn't, matter of Chen and circuits. I mean, this stuff is everything. I
mean, this is going to Supreme Court. When does Supreme Court announce who gets written stuff?
I do think it'll go to Supreme Court. They announced what they grant cert on, I want to say in the fall and really through early spring. There is a circuit split with that 11th Circuit decision at a minimum. I don't see how this in absentia issue doesn't go to the Supreme Court either next term or the term after.
I would say people need the thing is, as soon as possible to request reopening, because you never know what in the world is going to happen in the Supreme Court. But even if you request reopening, it doesn't, I don't know, immigration court, it's going to take like a year to even get a hearing or get it someone, could do that fast.
I don't think so. That's not a hearing. That's a paper. That's the papers. Honestly, DHS has no argument in those 4 circuits. Flat out, if it's an in absentia, that's on the papers. I used to work for the immigration courts and would
assist. This is a huge deal. This is like,
it's everything.
I want, like, the immigration lawyer nerds and stuff will get into this, but this should be on the cover of New York Times. This is like a really big deal. This is like,
well, I hope it's not, because I feel like
they politicized like hell.
We don't need to. I'd prefer not to go to the Supreme Court. I'm perfectly happy with these 4 circuits. Includes the 9th, which is where the most removal orders are. I mean, the 5th Circuit's rule is obnoxious and it doesn't make sense to me, and so maybe it should get resolved, but like, who knows? Like, Pereira was 8-1 with Alito in dissent. Ms. Chavez was 6-3.
Know precisely what you're aiming at.
Sorry, I'm getting my calculator out. I'm trying to see how much money. So let's say, like, how many cases on this? There's like 20,000 people will get hit by this or more. How does it look like?
I don't know how many people have been ordered removed in absentia since
at least 10,000.
I'm sure FAIR has the statistics.
I mean, I'd say 10,000 people. It costs at least 5,000 to deal with their case in some form or fashion. That's $50 million in the pot, but probably more both is going to cost more, and there's more people. Wow, this is like $100 million game probably, at least, like in our field all of a sudden.
Yeah, no, it's a lot. More important, it's all this relief for, you know,
Yeah,
individuals
definitely.
to
You talk about the humanitarian side, I'll talk the business side.
Yeah.
Well,
That's right.
thanks. This is like groundbreaking. I'm glad you're keeping us posted. I mean, if you watch our shows for the last 3 years, this is, or last how long, it's like this situation is like this slow train wreck. This happens, like this is happening. How is this gonna play out? I don't say a train
Yeah.
wreck is good that comes out of it, but
It's everything. It's everything. It's so huge. It's so like Nish Chavez was 6-3. I want to say the Chief, certainly Alito, and I'm not sure who else was in the dissent. So like, what's going to happen this time? I mean, clearly, it's going to be at least 6-3, I would say. And I mean, do you get a win? I'm a little scared because this is it's already so favorable, but it's inevitable, I think.
Yeah, the court doing like the textual analysis that they're doing, especially because of this majority, like they, I guess, gotta read it the way the majority of circuits are reading it. Because they have been doing that, like the Supreme Court, the way they've been handling things. So it does go pretty consistently towards this being law of the land.
Yeah, I don't understand. I don't see how the Supreme Court could hold otherwise, but of course, that's never.
Yeah, it's like a jury trial. You never know.
The 11th Circuit has already held otherwise. The counter argument is essentially that if you don't provide proper notice, you're not entitled to all these protections, including receiving notice in a court as the in absentia removal order statutes require. Or you could go back to like a two-step process that a notice of hearing cures it, but I do think Nish Chavez destroys that concept.
Yeah.
But I mean, that's essentially what the 11th held, and I don't really understand that because this flaw happens at the NTA before notice, before any address considerations even come into play. But, you know, you have at least one circuit who's already essentially held that, so. And then the fifth has like 8 decisions on this, depending on the context. The fifth is out of control. So, yeah, reasonable minds can differ in the South.
Interesting time. So, you know, if I wasn't so into USCI stuff and I was being my career, I'd probably go down this route and try to argue these, just make a career about at least the next 3-4 years, just hustling.
Make me a billboard, put my face on it.
We should start soliciting some business, but it's a tricky concept to get the client for them to understand, because you're gonna get a lot of calls from people who have like no idea what they're talking about. So you have to have a system. But inevitably, this is a big deal, and there's people who have money able to do it, so it's worth doing. I'm sure a lot
it's not even that complicated a motion. You write this motion one time, and then you replace the circuit precedent, and you're done. I mean, I've already written the motion, and that's without all this good precedent.
Maybe I'll hire an associate just to do this and do YouTube and TikTok ads, dance a little bit. Hey, in absentia order, they should not
do the thing. You point to the corners, and like,
Yeah.
you know, an in absentia order shows up, and a motion shows. I don't know.
No NTA, wrong NTA.
I don't know what the kids do these days.